International Criminal Court, located in The Hague, the Netherlands, is the first permanent court with jurisdiction over the most serious crimes, genocide, crimes against humanity, and war crimes committed after the 1st of July 2002. It was created and is governed by the Rome Statute, an international treaty between 114 states. According to the Rome Statute, the court may exercise its jurisdiction in situations where an alleged perpetrator of one of these serious crimes is a national of a state party or where the crime was committed in the territory of a state party. Kenya has been a state party since January 2005. On the 31st of March 2010, Pre-Trial Chamber 2 granted the prosecutor's request to commence an investigation of crimes against humanity allegedly committed in the Republic of Kenya. The Office of the Prosecutor is currently conducting investigations in the Democratic Republic of the Congo, the Central African Republic, Darfur, Sudan, Uganda, and Kenya. In this issue of ICC at a Glance, we speak with Gilbert Bitti, Senior Legal Advisor to the Pre-Trial Division of the International Criminal Court, about the Kenya situation.
For the moment, and since 31st March 2010, the authorization of the investigation in Kenya by Pre-Trial Chamber 2, we are in the stage of the investigation in the entire situation, as defined by the decision of the Pre-Trial Chamber, which is that the prosecutor now is investigating all crimes against humanity committed within the territory of Kenya between June 2005 and November 2009. After that, when he has selected some crimes and some people to be prosecuted, he will come to us with either request for warrants of arrest or summons to appear. For the moment, this is not the case. We are still in the process of investigating. This is in the hands of the prosecutor to investigate all the crimes against humanity within the territory of Kenya. When the prosecutor has selected crimes and persons that he wants to prosecute, he can appear before the chamber and either request a warrant of arrest or a summons to appear. This is regulated by Article 58 of the Rome Statute. He can do that under seal, so that nobody will know about those requests. He can do that also publicly, and then everybody will know about those requests. It is for him to decide if he wants to request summonses to appear or warrants of arrest. But it is for the chamber and for the chamber alone to decide if he is going to issue either warrants of arrest or summonses to appear or nothing, because actually the chamber has to decide on that, and it is for the chamber alone to decide. If the prosecutor wants a summons to appear, he has to prove before the chamber with documentation, evidence, of course, and he has to present solid grounds so that the chamber can establish reasonable grounds to believe, first, that the person has committed the crimes as described in the prosecutor's application, that there are reasonable grounds to believe that those crimes were committed by that person, and for a summons to appear, he has to convince the chamber that actually this person will appear voluntarily before the chamber. If he can prove that there are reasonable grounds to believe that the person has committed those crimes, but he cannot prove that this person will appear voluntarily, the chamber is not convinced about that, then the chamber can issue warrants of arrest. This is done in general in order to ensure the person's appearance at trial, in order to ensure that this person will not, for example, threaten witnesses, or will not interfere with the proceedings before the court, or that this person will not go on with the commission of crimes within the jurisdiction of the court. A summons to appear is an order which is served on the person directly, telling the person you have to appear before the pre-trial chamber on a specific date. If that person does not comply, then the chamber may issue a warrant of arrest. But that's an order, a written order, which is sent to the person. It's a convocation, in fact, to come before the court. A warrant of arrest is usually sent together with a request for cooperation to states, because we don't have a police. It's the states which are going to arrest the person against whom a warrant of arrest has been issued. Those states, when receiving the request for cooperation, and the main basis for this request for cooperation is the warrant of arrest, are under a duty, if the person is on their territory, to arrest that person, and after their national process, to surrender that person to the ICC. And that's a big difference because, of course, for the summons to appear, this person receives directly the document and comes directly voluntarily before the court. A warrant of arrest, that person is going to be arrested by a state, detained in the facilities of that state, and then surrendered to the court. The prosecutor may come either with a request for a warrant of arrest or summons to appear. The threshold is the same for both decisions. The prosecutor needs to provide sufficient evidence to convince the judges that there are reasonable grounds to believe that this person has committed the crime. The time taken, according to the examples we have, takes usually 2 to 3 months. In the case of al-Bashir, because of the amount of documentation presented to the chamber, it took 7 months. So it depends mainly on the amount of documentation presented by the prosecutor that the chamber does not control. The prosecutor has the duty to present enough solid evidence in order to convince the judges. It's for him to decide how much evidence he is going to present to the chamber. If the chamber is not convinced, the chamber may request more. That's possible. But of course, depending on the amount of documents, and the chamber has to review everything in order to see if there are reasonable grounds to believe that the person has committed those crimes, this will, as a consequence, determine the amount of time that the chamber needs. If there is a lot of documentation, a lot of evidence presented by the prosecutor, it will certainly take maybe 2, maybe 3 months before the chamber can take a decision. In addition to that, the chamber will have to determine if the prosecutor has presented enough evidence to convince, in case of a summons to appear, that this person will appear voluntarily or not. This is an additional assessment that the chamber has to make. Either the chamber will decide that there is enough evidence and that the person will appear voluntarily, and it will issue a summons to appear. If the chamber is not convinced, the chamber may issue a warrant of arrest. The final decision, warrant of arrest, summons to appear, after the threshold reasonable grounds to believe, is in the hands of the chamber. To conclude on that question, these are the possible options. Either to refuse to issue a summons to appear or warrant of arrest, to request more information before issuing or not issuing a warrant of arrest or a summons to appear, or to issue either a warrant of arrest or a summons to appear. This is for the chamber to decide at the end. When the chamber has issued warrant of arrest, there is always a possibility either for the person against whom the warrant of arrest has been issued or the state, in this case it will be the state of Kenya, to challenge the admissibility of the court. But this challenge has to come from that person or from that state. They must prove that there is a prosecution against that person, and it has to be for the same crimes as selected by the prosecutor, because it is for the prosecutor to select the crimes, of course. The last moment a state can intervene is the beginning of the trial. After the beginning of the trial, there is no more possibility for a state or for the accused to challenge the admissibility of the case. In addition, there is a clear obligation for the state to challenge as soon as possible the admissibility of the case. So logically, if Kenya thinks that it wants to challenge the admissibility of a case, it should do that logically at the pre-trial stage. Article 19 is very clear on the fact that the state should come to do the challenge as soon as possible. Of course, this challenge has to be based on genuine prosecution. So the state will have to prove that it is genuinely prosecuting that person. And it's not because a challenge is successful that that state has won so to say, that case forever. The prosecutor, even after a successful challenge, may come back to the chamber for the chamber to reassess the admissibility of a case. For example, if after a few months we see that the state is not anymore prosecuting genuinely that person, because there is no real investigation, because no witness has been contacted, because in fact there is no real prosecution, then the court can take that case back. So the process of admissibility is an ambulatory process. It's something that the court checks on a regular basis. It depends on what the state is really doing in concrete terms.